Welcome to County Portal, your simple source for local government services and public records. Let's get started.
Ever looked at a property deed and seen the letters care of next to a name and wondered what it means? Today, we're breaking down exactly what care of on a property deed is and why it's so important to understand. This small abbreviation can save you from big headaches and major misunderstandings about who actually owns a piece of property. Simply put, care of stands for care of. Think of it purely as a mailing instruction. It tells the county recorder, the tax assessor, and anyone else sending official documents where to mail correspondence about the property. The person or entity listed after C/O is not an owner. Let me say that again, they are not an owner. They are just the designated recipient for mail on behalf of the actual owner. Their role is completely administrative, to make sure important mail doesn't get lost. You'll see this used in a few common situations. One is when a minor owns property. Since a child can't legally manage their own affairs, a deed might read something like, Jane Doe, a minor, care of John Doe. Here, John Doe is the parent or guardian responsible for handling all property-related mail for Jane, who is the true owner. Another frequent use is with trusts. A trust, not a person, can own property, so the deed would say something like, the Smith Family Trust, care of Mary Smith, trustee. Mary Smith, as the trustee, manages the trust's affairs, and that includes receiving its mail. Businesses like LLCs also use this all the time. A deed might list 123 Main Street LLC, care of National Registered Agents Incorporated. The registered agent is legally required to be available to handle official notices for the LLC. Finally, it's often used for elderly individuals or someone who is granted a power of attorney. The deed could show Robert Jones, care of Susan Miller, where Susan is the trusted person handling Robert's financial and legal mail. The most critical thing to remember is that care of does not grant any ownership rights, title, or interest in the property whatsoever. The person named after care of cannot sell the property, take out a loan against it, or claim it as their own. Their name is on that document only to ensure that important papers, like tax bills or legal notices, get to the right place and are handled by a responsible party. The legal owner is always the person or entity listed before the C/O. When you're examining a deed, look at the grantee's name, that's your owner. The C/O part is just a component of their mailing address. Misinterpreting this can lead to serious legal and financial confusion, especially during a property sale or an inheritance. Hopefully, that clears up any confusion. It's a simple mailing instruction, not a statement of ownership. Thanks so much for watching. If you found this video helpful, please give it a thumbs up and consider subscribing to our channel for more real estate tips and explanations. Don't forget to hit that notification bell so you never miss an update, and if you have any questions, drop them in the comments below. We'll see you in the next video.